Employment at will means that you can be fired at any time, but the side that they show is good for employees is you can quit at any time. But employment at will, generally benefits the employer more than the employee, and so you can be terminated at any time for anything as long as it's not a discriminatory reason or retaliation. If you've been facing discrimination and you've made a complaint and then they terminate you, that could be retaliation. Other than discrimination and retaliation, it might be morally wrong and it might be terrible how it happened, but there might not be legal recourse.
So you hear a lot of, even though we're in an at-will state and most of the states are at-will, I think that a lot of employers are always worried that they're going to get hit with a retaliation from an employee because this is discrimination or this was retaliation. It sounds, the way you're describing, that a lot of those cases are going to fall flat and they're not actually going to be pursuable. But what should employers consider when they're letting somebody go? The assumption is they're doing things right and they're not doing it for discriminatory and retaliatory purposes. What should they do to protect themselves?
To summarize, before you get into it, employment at will means somebody could be fired for any reason and no reason, right? I could just come in one day and say, I don't like the way your shirt looks, you're fired. Or you smell like cigarettes, you're fired. And so an employer that wants to fire somebody, there's a couple of landmines, let's just say, that could trigger something. So there's age discrimination, which means, anybody over 40 is in a protected class. So if you fire somebody that's 60 and replace them with a 25-year-old, you might get sued. There's the protected classes, which is, sex, color, nationality, religion. I'm probably missing a couple off the top of my head. Maybe Aubrey can correct that. But again, if let's say you lay off 10 people and your company's got 100 people and every person you lay off is of one nationality or of one sex, you're probably going to get sued. There's a disability discrimination. So if somebody has some sort of disability and they come in and say, hey, I got to take medicine every day at 12 o'clock and, their eye drops and I can't see for the next half hour. So, I need an accommodation to have a lunch break at this time every single day. And you're like, I don't want to deal with that. You're fired. Those are the types of lawsuits that you're almost guaranteeing yourself a lawsuit. Mm-hmm. To protect yourself as an employer, you have to, keep these things in mind. And so if you're going to fire somebody that's 55 for a legitimate reason, maybe they're not doing a good job, and your intent is to replace them with somebody that's under 40 or substantially younger than them, you should document all the ways that they're not doing a good job.
Right.
And so a lot of companies, they'll have employment handbooks. One of the things that we say all the time is, do you have an employment handbook? What's your employment handbook say about this? If your employment handbook says that you're going to get, 3 warnings before we fire you, and then you fire somebody after the first warning,
you just breach your own handbook.
Right. And again, that's not binding law, but that's something that's more likely to get you sued.
Right.
Right? Because maybe the infraction is so bad on the first time that it warrants somebody being fired. So again, it's not a bright line rule every time, but these are things to consider. If you don't have an employment handbook and you just fire somebody, they might ask, did you have an employment handbook? Right? So there's constantly this back and forth, and I guess that's why we have lawyers and that's why people hate lawyers, is because there's this, it's like, well, I did it all the right way, but did you think of this?
Right.
And so but from an employer standpoint, one of the things we always say, especially as you get larger as a business, that you should have some sort of system. You should have some sort of systematic way that you approach things. When you have 5 employees, when you have 10 employees, it's not really reasonable for you to have HR, right? It's just going to be somebody that is the CEO or the president or the owner of the company. They're HR, essentially. Maybe they have a manager that helps them make those decisions, but that's it. When you have a company that's got 30 people, 50 people, 100 people, you probably should have a department that
manages these things
and oversees these things. And you really also want to have, and Aubrey brought up a good point earlier, is that you can get sued personally as the decision maker for not paying wages. The same kind of thing goes for discrimination or retaliation. So the person that, knowingly or actively participates in the discrimination and the retaliation, they can get sued personally also.
Mm-hmm.
And so if you're the owner of the company, you really want to detach yourself from that. You want to say, okay, HR handles this. We have a performance improvement plan. We gave you a verbal warning on October of 2024. You did okay for 2-3 months. Then in December, we had to give you a written warning. Right. And, you did okay for 2 months again. And now it's February and, you're just not living up to your skills, what we expect you to do, what we're paying you. And so if you've papered that well and then you terminate that person, when a lawyer comes knocking, for whatever reason they're going to come knocking, because they will come knocking, you're going to say, well, wait a second, here's, exhibit A, B, and C of the things that we did right. And that will help you defend yourself. And then you take that to a lawyer like us from the employment side. And that's really what you want to do, because they're going to say you discriminated anyway. They're going to say you retaliated anyway.
Okay, quick question. When you're doing these 3 strikes, you're out sort of thing, is it baseball rules, 3 strikes, you're out with these things, or is it lethal weapon rules? Do we go 1, 2, 3, go? Or is it 1, 2, go on 3? Which is the...
It really is whatever you say it's going to be. And you don't really have to have 3 strikes either. You could have 1 strike. And, if you catch somebody stealing, it could be no strikes. Hey, you stole from us. You're fired.
Right.
It doesn't... And we've worked on employment handbooks. We've put them together for companies that are getting a little bit bigger, that need some sort of documentation and some sort of standards that they go by. And those employment handbooks will say things like that. They'll say, here's a list of things that are infractions that you can't do at work. You can't come to work drunk and high. You can't bring weapons to work. You can't threaten people at work. Maybe there's a dress code. You can't use your cell phone at work. Some places care. Some people.
This is assuming you
care.
don't work at like a gun shop dispensary sort of thing. But
yeah,
that's fine.
Exactly. I don't think they want you coming to work high at a
I
dispensary.
I don't know that they've done that combo business yet. It's a great idea. It's a great idea.
So, but we have those in the handbook, and the handbook will say something along the lines of, we can terminate you on the first infraction if it's bad enough.
Sure.
And so then you can always rely on that. But the thing that we tell employers to think about is really to keep it consistent, because, if you have 8 guys and 8 women working in a workplace, and for whatever reason, the guys get 3 warnings and the women get 1 warning, you're going to get sued.